I was the editor of Exero, and I suppose we led the charge in publishing stories about allegations concerning VIPs and child sexual abuse. And I suppose our reporting led to the setting up of, which has various strands, Westminster, as it were, being one of them, wrote about somebody who was known by the name of Nick, who went on trial himself over the past 3 months or so. He was charged with attempting to pervert the course of justice and with making a fraudulent compensation claim. And a couple of weeks ago now, he was convicted on all counts and was sentenced just over a week ago to 18 years in prison.
With the Nick conviction, there's been a lot of talk about this over the last couple of weeks, actually. I think it was Monday before last. The sentence was announced, or the conviction was announced, and then last Friday the sentencing. What do you think? How sound was this case? Because I know there was quite a lot that the jury were not allowed to hear by the judge.
Yes, well, I do have real concerns about the way the trial ran, which leads, in my view, to the convictions being essentially unsafe convictions. And my concern falls into two broad camps. Judicial rulings on the one hand and material relating to the evidence on the other. On rulings, there was a ruling before the trial started that the prosecution was going to be allowed to tell the jury about the fact that the defendant, Carl Beech, had pleaded guilty earlier this year in a separate case to downloading and possession of indecent images of children. Now, normally, as I'm sure you're aware, you cannot tell a jury about any previous convictions because of the risk of prejudicing them. And my view was that that ruling was highly prejudicial, and quite frankly, it didn't really matter what evidence would surface in the case. The jury was always going to convict him because they'd see it through the prism of his being someone who had downloaded indecent images. Terrible as that is, I think an absolutely heinous crime that he definitely did commit by downloading those images, and one charge of voyeurism. I believe that the jury shouldn't have been aware of that and should have assessed the evidence of attempting to pervert the course of justice on that evidence alone, and there shouldn't have been the prejudicial point about the previous convictions. Separate to that, there was a ruling about evidence relating to Harvey Proctor. There'd been limited disclosure very late in the day to the defence by the prosecution, which related to the police investigation into Harvey Proctor in the 1980s, around 86, 87, and in relation to the property search that was carried out under Operation Midland, i.e. the investigation into Nick's allegations, the property search carried out on Harvey Proctor's home in March 2015. And the defence wanted two things. They wanted further disclosure on this material because, as I say, they had limited disclosure. But they also wanted to be able to cross-examine Harvey Proctor about it, about these two elements. And basically the judge said no to both. So I think those rulings are critical to the way in which the trial was shaped. But I also think that there were some problems with the evidence. We know that, and we certainly knew at Exero, that the Met considered Nick, Carl Beech, to have been a credible witness, and we knew that well before they publicly said so. But what the trial never heard was the basis for that assessment by the Met officers on the case. It's been widely talked about. There's been this widespread assumption that the Met simply automatically believes their witness because that's the police policy. But in fact, that's not true. I mean, it is the police policy, and that is true. But what isn't true is that is why the officers believed him. There's more to it than that, and the trial didn't hear about that. And the other thing that the trial didn't hear anything about was any insight into the possible effects of childhood trauma. Now, the prosecution attempted to, their speculative case was that here we have someone who was interested in downloading indecent images, and that was why, by their account, he made up all this stuff about abuse by VIPs. However, in my view, there is clear evidence that he certainly was sexually abused in his childhood, putting aside the issue as to who by. He certainly was sexually abused in his childhood, and that, of course, the traumatic effects of that, we simply heard no evidence as to how that can manifest itself. For example, in how such a person gives an account of what happened to them, and indeed in relation to behaviours that can follow on from that past. So I think the trial was very troubling in the way in which it was conducted, and I think it means that the end result cannot be relied on.
So does that mean, do you think, Mark, that there may be an appeal after this?
Yes, I mean, it is possible, and my understanding is that is something that the legal team on behalf of Carl Beech are looking into. But they haven't made a definite decision on that, and I suppose they don't have to. My understanding is that you have 28 days from the point of the conviction, which, as you said, was the Monday before last. I think I've got that right. So 28 days from then if you want to appeal against the conviction, or 28 days from the sentencing if you want to appeal solely against the sentencing. And I suppose the areas of appeal that I certainly think should be advanced will be over the rulings. The refusal to force a greater disclosure on what Operation Midland found and on what other investigations found into allegations against various VIPs, and the rulings that shaped this case in terms of blocking cross-examination over certain matters of Harvey Proctor, and the initial ruling about allowing the jury to know all about the previous convictions that Carl Beech had.
So, I mean, there's a lot to take in there, but I think maybe one of the most striking things about this case is why were the jury not allowed to hear why the Metropolitan Police decided, after having a look at Nick's evidence, or Carl Beech's evidence, that actually that there was definitely something to it. I mean, that was their conclusion, and it seems strange that the court would not be that would not be explained to the court.
Well, I think there are two elements to that. I mean, one, I think from the defence point of view, they kind of hoped that would become clear if there'd been full disclosure on material gathered by Operation Midland, but because it's clear they only had, well, they said in court they had very limited disclosure. I mean, I did tweet the figures at the time. I think one of the witnesses referred to how much material there was and how much material had been disclosed. It was a tiny proportion of the Operation Midland material that was actually disclosed to the defence. So if they'd had full disclosure, then the defence would think that it would become apparent from that why it was that the police officers took him to be so credible. And indeed, infamously, of course, the police actually said publicly in the early stages of the investigation that they regarded him to be a credible and true witness.
Is it simple when in the cases like this that really this is about one lawyer against another, and about how good and clever and well funded one legal team is than the other one? Because I would imagine that Carl Beech doesn't have quite as much clout and money as some of the people he's up against.
Yes, I mean, I think in a sense there's an element of truth in that for all cases. I mean, anybody who is being tried on a charge is up against the resources of the state, and they're reliant on their own resources, and with perhaps some assistance from the state, of course, in the form of legal aid, but it's not really comparable. And I suppose that battle is a little bit more equal if you have significant resources yourself. So I think that's a point that can be made in any case. I think here the kind of disparity of arms was perhaps not so much about resource, though, as access to information. As I say, the defence team were often acting in the dark. I remember, just to give you a little example of how that manifested itself, there was a reference to a schedule of items that were seized from Harvey Proctor's home by Operation Midland in March 2015, and one was a reference to a notepad that was seized relating to child sexual abuse, but it wasn't specified what exactly it was, and it was just a list of items. Of course, the defence wanted the items themselves so they could assess, what was there, and the prosecution actually stood up and said, well, we can't give you these items even if we wanted to, because we don't have them anymore. We gave it all back to him. And the judge, before he made his ruling on this specific point, this specific application, did say that he made this point that, well, I'm completely in the dark, you're in the dark, referring to the defence team, I'm in the dark, and I've got to make a decision, or words to that effect. And there was a sense dark on some of this evidence. There was also a reference to indecent photographs, which the court assumed were legal, bearing in mind no legal action, no criminal action carried on. There was a particular officer who had seized all these items, and the judge said perhaps we ought to have this officer back to tell us more about all this, but it never happened. So there were these great black holes in the midst of the trial.
What about the sentence of 18 months? I mean, this is in some of the commentary. Years. That this is actually likely to have a chilling effect on any survivors of child sexual abuse thinking of coming forward, because, and also, of course, on potentially on the reporting of this sort of thing as well.
Well, several points there. I mean, first of all, it is possible for attempting to inflict the course of justice to get a life sentence. So, in one sense, it could have been worse, but in another sense, I think if you think about sentencing practice, I think it's a very heavy sentence, 18 years in total. That's the prison sentence. That's the sentence he received, although he will serve half of that in jail and will be released on licence unless something else changes, but that would be the normal course of events. In terms of deterrence, I do think that, clearly, if you're guilty of something like this, then you deserve to be convicted and deserve to go to jail for it. The question comes down to whether you're guilty of it or not. And I think, I think one of the things one has to remember is that anybody who comes forward to make claims of sexual abuse, almost of any type, but certainly from childhood in particular, it has such a damaging effect on such a person that the way in which they behave and the way in which they recount their experiences do not fall into neat boxes in a way that people who are not familiar with this area perhaps realise. Now, the judge did make the standard warnings about not falling into stereotypes, but I'm afraid I think the whole case really shows that the criminal justice system is ill-equipped to handle evidence from people who claim to be victims of serious sexual abuse in their childhood. Because I think the other point I was trying to remember earlier that is crucial is we didn't hear any testimony relating to the possible effects of childhood trauma. There was no insight into whether this person who was in the dock, whether he was someone who displayed symptoms of actually having suffered child sexual abuse or not, putting aside the issue of who by, but whether he was displaying those traumatic effects, or whether it was all put on, as of course the prosecution was seeking to establish.
And one of the cases that springs to mind after this, Mark, is the case of Gordon Anglesea. He was someone who was completely exonerated, as in some ways Harvey Proctor could said to have been, of any kind of hints of child sexual abuse. And then afterwards it was discovered actually he had been a paedophile, even though he was a police superintendent. So these cases do have a habit of sometimes going one way and the other. I wonder whether you think that we've heard the last from Nick or Carl Beech.
Well, I think your point there goes to the issue of basically the criminal justice system is ill-equipped to get to the truth or to assess, whether someone coming forward to make allegations of sexual abuse, particularly child sexual abuse, they're very ill-equipped to handle it. And I suppose the case of Gordon Anglesea illustrates that, because of course one civil court one time basically concluded that the witnesses were lying and that he was not a sexual abuser of children, or had not been. And then of course many years later a criminal case came to the precise opposite conclusion. So I think the one thing you can be sure of is that the criminal justice system was wrong on at least one of those occasions. So
finally, do you think we're seeing, with the precedents set in these cases and new legal rulings and even new legislation, a slow change in the law with relating to child sexual abuse, and whether you think that it's moving in the right direction or not?
Well, I suppose one of the things that will happen is there'll be a concerted effort to sort of exploit this case to to increase the pressure to stop naming those accused, for example, those arrested, or even I think through to the point of being charged. And I think what that points to is pressure for even greater secrecy within the criminal justice system in Britain than we already have, which I certainly do not think is the answer. We do not need greater secrecy in our already overly secretive culture.
Mark, where can people follow your work? I know you've got I think it's www.foiacentre.com website, but where's the best place to follow what you're doing?
Well, I mean, it's probably best to follow me on Twitter at @markwatts_1, and if you look through there, you'll see the link to quite a detailed article that I wrote about that crucial ruling over the evidence relating to Harvey Proctor, a full playing out of what was said in court about the evidence that the prosecution had disclosed to the defence, albeit in a limited form, what it was they were asking for. And I will, of course, inevitably be returning to the subject.
Okay, Mark Watts' website is www.foiacentre.com, and he's on Twitter at Mark Watts. And I'll put a link up to that article Mark's just mentioned there. Its headline is Harvey Proctor had sexual interest in young boys. Judge in Nick trial heard without the jury, on our show page at thisweek.org.uk. Mark Watts, thanks very much for joining us.
Thank you.
Martin, what do you make of this?
Well, it's interesting, isn't it? I've not been following it as closely as Mark has, obviously, but it's quite clear. We had, do you remember we had, it was a Detective Sergeant Wedger, wasn't it, from the Metropolitan Police?
John Wedger, yeah. John
Wedger. And he was telling us how difficult it was to prosecute these kind of cases.
He was just a DC, Detective
DC, right, yeah.
And he was saying that as he was starting to get close to prosecutions, he was basically told to lay off, and in fact even had threats to take his home away from him.
Well, eventually drummed out of the police, as you know, but he was saying that, and one of the points he made was that a lot of the kids that are abused through they basically go to children's homes and places like that. They're very vulnerable, and of course they're in the power of the state, really. And, of course, powerful people are able to get access to them, like the Kincora Boys home scandal in Northern Ireland, where MI5 were implicated in what they were doing there. And then when they come, in later life, they tend to have problems. They're alcoholics, drug addicts, they download child pornography. And, of course, their characters can be blackened very easily. And it's very difficult then for them to be credible witnesses in front of respectable juries.
I mean, we had an example a few years ago on this programme. If you want to go through our archives, you'll find it. It's a guy called Jim Gamble, who was a computer expert. He was an expert witness, and he was prosecuted, or there was an attempt to prosecute him by, I believe, Avon and Somerset Police, where Colin Port was the chief constable, for having images of child sexual abuse, which, of course, is a criminal offence. But the thing is, he had them to analyse for the courts. And they were trying to prosecute him as if he was himself a paedophile. So there's quite a lot of nasty stuff goes on in these cases, or can do.
Well, indeed.
Well, I'm also joined by Tony Carey. Sorry to drop you in the deep end with this rather nasty national story, Tony. But what do you make of what you've just heard? And just the general, I suppose, the main thing is, what is the effect of this? This is what bothers me, is that those who either themselves have been abused or know people who've been abused may think twice about going to the police now when they've seen an 18-year sentence handed down to
That's exactly the point, that as soon as I saw the outcome of the court case, that's the immediate reaction I got. And also, I often wonder if the characters who were accused of these assaults and subsequently been found not guilty were ordinary members of society, whether in fact it would have been 18 years or whether it had been a much lesser degree. I think that the characters, the status of the characters has resulted in Carl Beech being imprisoned for a much longer period of time than would have happened if it had been you or I who had been accused.
Martin, it does seem to have been tainted, this whole scandal, by the fact that the implications of very rich and powerful people being involved.
Well, I think I mentioned Kincora Boys home earlier, and it's a big scandal in Northern Ireland because it's all well known. They basically, MI5 were using it as a honey trap, so various political figures would go in there, have sex with underage boys, they'd be photographed, and then they were blackmailed politically. And I'm afraid that that's the sort of thing that's been going on not just in Northern Ireland. And of course, there's a use of paedophilia as a form of political blackmail on senior politicians and others. Yeah, so it's a strategy that's pursued by intelligence services, and we're sniffing around the edge of it here.
And yet, only yesterday the day before, maybe, we suddenly hear now that Nottinghamshire Council suddenly realised that there are up to 350 children have been being abused on a regular basis, maybe up for the last 4 or 5 decades. Yeah. One wonders where people, how deep their heads must be in the sand not to realise that this sort of thing goes on, and they should be looking so closely. And I'm sure it isn't. But if such a thing were to be found happening in Bristol, I would be mortified. And I really think that would be the one occasion, one thing that would make me want to leave my city if something like that was going on. Young people deserve every protection we can give them.
Well, they certainly do. And one of the shocking things Mark was talking about there is just a failure of the justice system. So this is just the justice system supposedly crunching around, a judge looking at all this, and then an unsound verdict coming out where certain important bits of evidence are not being heard. In another case, earlier this month, or last month actually, Yousef Makki was killed in Manchester, and 2 boys were found not guilty over a fatal stabbing of him. Now, I thought we were trying to do something about knife crime. Yousef Makki was a 17-year-old grammar school graduate in Manchester, and he was stabbed in the heart. But apparently it's not murder. 2 boys have been found guilty over the death of... This is back in... Just looking for the date on here. That's the 12th of July. Of the death of Manchester Grammar School pupil Yousef Makki. As a jury returned their verdicts at Manchester Crown Court, Yousef's father was heard to shout from the public gallery, "Where's the justice for my son?" The A-level student, 17, from Burnage in Manchester, passed away in hospital in March 2019 after he was stabbed in the chest on Gorsebank Road in Hale Barnes. 2 youths, boys aged 17 who cannot be named for legal reasons, have been on trial for almost a month, facing several charges in connection with his death. But they found the court found that they were not guilty of murder, or the guy that actually stabbed him wasn't guilty of murder. It was all in self-defence. And so this boy A, who can't be named, also 17 years of age, is going to be serving 8 months, I believe, of a 16-month sentence, and then he's out after stabbing someone in the chest and killing them. That apparently is no longer murder in this country. But to add insult to injury, actually in the courtroom, boy A went into the toilets and filmed himself doing stabbing motions, posted it on the internet, and then that was sent to the family of the victims. So it does seem as if the courts are not really doing their job, Martin.
Well, I mean, the problem with all of these things is each case is individual. I don't know anything about that case apart from what you've just told me. And that's not to do with VIP paedophilia, it's to do with stabbings, a wholly different topic. I really don't know what happened there. It doesn't sound right. Yousef
Makki's dad collapsed in court after the boy was cleared of his murder. I can't call him a murderer because he wasn't accused in court, or wasn't found guilty in court of being a murderer. Then went and took the mickey by going almost being sending out triumphal videos about how he's got off.
Well, it doesn't sound right, does it? But then that's there are miscarriages of justice in the best systems.